In a case before the U.S. Supreme Court, the Biden administration and attorneys general from 9 states are asking for the justices to uphold warrantless home entry and gun confiscation by police. The case involves a domestic dispute between an elderly married couple, Edward and Kim Kania, which resulted in the police manipulating Edward into a psychiatric evaluation and ultimately confiscating his weapons, despite officers admitting in their incident report that he seemed normal and was calm for the most part. The police relied on a narrow exception to the Fourth Amendment called community caretaking, designed for cases involving impounded cars and highway safety. The attorneys for Kania argue that extending the community caretaking exception to private homes would be an assault on the Fourth Amendment and would grant police a blank check to intrude upon the home. The potential problems with such permissions are highlighted by the case of Breonna Taylor, who was killed in her home by police after a no-knock entry, tied to a falsified warrant, led to cops spraying her apartment and surrounding ones with bullets. The case created a national firestorm that elevated conversations around Second Amendment rights and self-defense, no-knock warrants, Fourth Amendment protections, and the need for policing reform and accountability. If the Biden administration gets its way in this case, it is scary to imagine what law enforcement might get away with. The expansion of police powers almost always impacts marginalized communities more harshly. The arguments presented in this case are a clear violation of both our Second and Fourth Amendment rights. A rule that allows police to burst into your home without a warrant whenever they feel they are acting as community caretakers is a threat to everyone's security. Subscribe Libertarian Facts.